California is a state with a big reputation of taxing and nickel and diming their residents to the point where many threaten and some actually do leave. While yes, we do have to contend with things like having some of the highest gas prices in the country, sometimes I'm shocked to find that California has more lenient rules than many other states in other aspects. One of those is the probate threshold for one's estate that is not comprised of real property, a small estate. That number has gone up again as of April 1st, 2022. No, wasn't an elaborate April Fool's joke on its residents. California is allowing you to have a little bit more money in your estate when you die before your family has to go to a probate court. And here's the kicker. This number is set to increase again in 2025 tied to inflation. So let's talk about that. Hi, I'm Andrew Bethel. And being a part of an estate planning law firm, we always need to be on top of estate planning laws to guide our clients down the best path and allow them to keep the most of their wealth in their estate to pass on to their family, rather than to Uncle Sam. Yes, the government needs funds to fund public functions, but if we're allowed to work within the law to preserve what we can for the family, why not utilize those tools and create generational wealth, no matter how much you may have to pass on? Regardless, if you've dealt with a probate or an inheritance, then you've likely seen or heard the phrase small estate used in such a way as to imply more than simply saying someone's estate is, well, small. In the estate planning world, small estates actually refers to the maximum amount of value one can pass, excluding real estate, without the need for a trust, a will, or even a probate. A decedent's heirs sign a form, typically called a small estate affidavit, and present it to the bank so that the bank can then release the funds to them right then and there. In that affidavit, the heirs are swearing that the estate is one of a small value, a small estate, and that they are entitled to the funds. They must have their signatures notarized, present an original death certificate, and wait 40 days from the date of death. But otherwise, that's it. An example of this is, let's say we have a single man named Frank, and he has two children, Sam and Dawn. Frank was living with Dawn by the end of his life and had sold his house after his wife passed many years prior. By the end of Frank's life, he had a pension and two bank accounts, a checking and a savings, which when added together equated to $170,000. Upon Frank's passing, his pension ends, leaving only his two bank accounts. Frank never made a will or a trust. If Frank died on March 31st, 22, Sam and Dawn would be required to go to a probate court to inherit those funds from Frank's two bank accounts, since he was over the small estate threshold of $166,250, and they would lose over $8,000 off the top between court and attorney fees. However, if Frank died just one day later, April 1st, 2022, when California raised the small estate value, then Sam and Dawn would only need to wait 40 days, sign the small estate affidavit, and present it along with an original death certificate to the bank for the bank to close the accounts and give the money equally to Sam and Dawn. This is because back on April 1st, the threshold for what was considered a small estate in California was raised from $166,250 to $184,500. That's an increase of over $18,000 more dollars that you can have before your family needs to worry about probate. There were some other increases that happened on April 1st as well. First, we have real property of small value. While all real estate in California triggers a probate issue, real property of small value can be passed on with a shortened and less expensive procedure. Still probate court, but a shorter time frame. This value increased from $55,425 to $61,500. Next, if a decedent had any unpaid compensation due to them, unpaid salary or unused vacation, for example, then that compensation, up to a certain amount, can be excluded from the value of the estate when calculating whether the estate qualifies for a small estate affidavit procedure or not. This went from $16,625 to $18,450. Finally, we have the small estate set aside. This is where the net estate, as in after taking out all debts and expenses, excluding the value of a home, does not exceed the set aside number, thus allowing the entire estate to be set aside for the surviving spouse or domestic partner and minor children, thus avoiding a full-blown probate. This figure was $85,900. As of April 1st, it is now $95,325. Again, these numbers are scheduled to increase in 2025, although we do not yet know by how much since they are tied to inflation. However, keep in mind, small estate affidavits are essentially financial intangible assets only. Real estate is not included, and if you have real estate, then we have a potential probate issue. And if a probate is required, all of your assets, even if you only had, say, 100 grand in the bank, will become a part of that probate, driving up the cost, time, and headache for your family. Avoid the probate on your real estate and set up a living trust. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here, but don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.